Good evening, everyone, and welcome to Lawctopus Law School's free and open webinar on how to do legal research for a moot court competition. First of all, I'll give you a little brief about Lawctopus Law School, guys. We are an online law school. We provide skill-based online certificate courses where you get to learn a lot of such things which you usually do not learn at law schools. So today's webinar is basically about how to do legal research or for a moot court competition, guys. So this is officially the mooting season of the year. A lot of moot court competitions are going on, and I'm very sure that most of you all are in their law schools and you are planning to participate in moot court competitions. So before we proceed further with the session, I want all of you to just quickly write down in which year you all are, so that we'll just get a quick hint about you all, and we'll accordingly start our session. So just spare a few seconds and write down in which year you guys are, everyone, in the chat box, please. Guys, please check if you can access the chat box now. Yeah, good. Great. Okay, first year, second year, first year, third year. Okay, early years of law school. Very nice. Great, guys. And how many of you are planning to participate in a moot court competition anytime soon? You can just write a yes if you're planning. A lot of you. Great. Almost all of you. Okay, then I'm very sure that this session is going to be very beneficial for you. With us today is Paras Aneja. Paras Aneja is going to be the main speaker of this session. Paras Aneja is an assistant professor of law at Jaipur National University. And during his law school, he has participated in a lot of moot court competition, and he has won a lot of moot court competitions as well. He's been a legal practitioner and he's practiced in Delhi. And during that time, he has even judged more than 30 moot court competitions. So he knows a lot about mooting, and he'll know a lot, he'll tell you a lot about the insights of mooting. Particularly, we're going to discuss about the legal research part of mooting. It is just one component of mooting. Mooting involves a lot of things. It from drafting, legal research, oral arguments. Today in this session, we'll only be covering about the legal research part. So, yeah, Paras, over to you.
Thank you, Mansi. Good evening to each and every one of you. As you have been informed that this particular session is about how to do the legal researching, correct? So before starting and telling you about the Moot Court competition, let me sail you through the concept of the society, which is a part of the political science. I hope most of you, and in fact 60-70% of you are pursuing BLLB honors or even LLB after completing your BA. So there's a concept of society which talks about social contract theory, right? This is the theory which has been propounded by Hobbes, Locke, and Rousseau. It says that it is the responsibility of the state to provide, protection to the citizens, and against that protection, the citizens would vote to the state, right? The extension of this theory also gives birth to the idea of the grand norm. This is another theory which is being given by the Hans Kelsen. It says that in a particular state, here state means I am talking about India, there is a parent law, that is the top law, which derives its authority to each and every law in the country. And for that matter, we have the Constitution of India with us. So every other law means IPC, CRPC, evidence. It derives authority from the Constitution. I'll give you an example of Article 21 of the Indian Constitution. It says no person shall be deprived of his life and personal liberty except according to the procedure established by law. So the procedure established by law here is CRPC 1973, right? And in order to make it more clear, we all have heard while participating in any of the Moot Court competition, some of the terms which we usually use at the page of prayer, because this session is not of drafting of the memorial. So the keywords are justice, equity, good conscience, right? These are such elements which, when crisscrosses, the elements like non-arbitrariness, non-fancifulness, non-oppressiveness, right? They all form the basic elements of the Constitution, right? The idea of telling you all this is to make you understand regarding the jurisprudential and the constitutional essence of any of the statute which you would read and prepare before moving ahead for any research for a particular moot court competition, whether it is a national moot court competition or it is a national international moot court competition. Most importantly, why this mooting is important for you all, because when you are in law school, you learn the art of advocacy which would be requiring for you after your graduation. Today, in most of the law school, students are having this idea that we'll be preparing for the judicial services, or we shall be joining some of the corporate houses, or we will be going for the litigation, right? And there is also a misconception that participating in moot court competitions is of the relevance only in the corporate sector. If you want to join any of the top tier law firm, only there the moot court competitions are helpful. That is not the case. Mooting is helpful everywhere. Even if you become a judicial officer, that is there. It is very important because you should know how to marshal the law. You should know how to, marshal the arguments. You should know the story of both the sides. Ultimately, it is a dummy court because you have to contest against your opponent, and you have to persuade the judge in order to win that particular matter. Because today you are learning, and after 2 years or 3 years or 1 year or immediately after a few months, you have to make your client win. I'll take you and I'll sail you through a small description of this. So as you can see that as I've discussed about why mooting, so indeed it's an art of advocacy, the foundational aspect which you tend to learn starting from the first year, the concept of the acceptance and justification which helps you to move ahead in the legal arena, the intramural and intermural kind of activities which are organized at the various law schools in the country, helps you to hone your argumentative skills, helps you in the sharpening of your legal acumen, your legal reasoning, and indeed importantly helps you to think syllogistically. Coming to the legal research, the ultimate objective is to persuade the bench or the judge before you argue, even if it is a moot court competition. The idea of the ancient Greeks, this is something which is related to history. I'll try to connect it that way. Aristotle, he has given the three means of persuasion because he has seen that the audience are more convinced by the idea of a speaker when you speak with a lot of reasoning, and this particular reasoning will overpower the audience in terms of the three variety of the means which he has given. The first is ethos. For ethos, he mentioned that ethos shows the credibility of a speaker. If you are speaking credibly with the complete reasoning, your credibility attracts and makes a lot of impact factor on the audience. On the other hand, pathos talks about the emotions of the audience. This is somewhere you can connect to the idea of the style, posture, and demeanor which is required for a mooter before the judge. The way you stand, the way you dress up, the way you address the bench, right? The way you pass on the chits. Because in a moot court competition, specifically when you participate outside your particular law school, there's a team of 3 people, correct? So the researcher has this responsibility to pass on the chits to the bench with the help of the speakers. So all such activities which you show, the mannerisms which you show before the court, all this is a part of the pathos. So Aristotle believed that the ethos and pathos, they have such an impact factor in the public that that would create a different kind of distinct identity of a person who is speaking on a particular topic. The third is the logos, which talks about that what is said. What is said means here it connects to what decision is being given by the court, in the sense that the reasoning which is inherent in an argument, right? You can also connect this particular reasoning inherent in the argument if you have heard about the concept of the ratio decidendi and obiter dictum. Ratio decidendi, which talks about the reasoning, and obiter dictum, which is the observance of the court. So this is a well-reasoning speech, and it is more persuasive than a speech containing the logical flaws. So Aristotle believes that if you are in a public and giving a logical speech, right, that will be very helpful to persuade the judge instead of committing the mistakes. So such are the activities which will help you to move further for winning a particular matter before the court. Now there are some of the these are the forms of the legal reasoning. There are just two forms, deductive and the inductive. As you can see that Aristotle has mentioned that no one has seriously challenged him in the nearly 2500 years. All reasoning is either deductive or inductive. The persuasive legal argument is therefore founded on valid deductive or inductive reasoning. What are these? If you understand the concept of syllogism, as I mentioned that you should think out of the box. You should think syllogistically if you have to win an argument. So this deductive reasoning, as it is clear on the screen, it draws a chart that they are talking about the general rules, the general principles which are above the specific situations, which are above the specific facts, which are not completely but partially valid in a particular matter, right? With the help of the syllogisms, as it is mentioned, the major premise of a particular argument is that all mooters, all of you who are listening to me, you all mooters are the law students. But the minor premise of is this, that one of you, for example, Mr. Rajat is a mooter. And the conclusion is that Mr. Rajat is a law student. So here you can see that the major premise has overpowered the minor premise, right? Which is giving the fact that Mr. Rajat is a mooter. Further, deductive reasoning, it underpins all legal arguments in rule-based systems of law. Basically, here they are talking about the concept of the English law. I would try to connect this that way, is that we all read law of tort. Not all of you, some of you might have read law of torts, or some of you will be reading that particular subject in the future. So law of torts is connected to the English law, right? Or you can say the Court of Hammurabi, right? Or the Magna Carta, which is 1215, right? So besides everything, if you understand that in the Indian Constitution also, we have taken the branches from the various laws. And that is how the entire grand norm, the entire document is prepared, right? And circulated and floated to drive the authority to the other laws which are preparing every day. So this link which is established between the legal rule and the general application of the facts in terms of the English law and the law which we prepare for the competition, right? It is done so to arrive at a particular conclusion. That is how the deductive reasoning, that is how the deductive idea of Aristotle works. To make it more clear, the major premises that a generally applicable legal rule. For an example, Article 14, Article 19, Article 21. They are the golden triangle. The minor premises, relevant facts of the moot problem, which is incorporated in your fact sheet. The conclusion is the decision that the moot court should make. That means the decision which will be given by the judge. The lawyers which you will be in the future and the mooters which you are at present, they derive the rules for the major premises of their deductive arguments from the recognized authorities. So everything is so connected that it is forming the part of the same transaction again. Now, these mooters and lawyers, when they talk about the major premise, they are trying to connect this particular fact with the authorities. What are authorities? I'll give you an example. The judgments passed by the lower courts or the higher courts or by the apex courts, all of them are authorities. To what extent they are recognized by the lower courts, to what extent they are recognized by the legislature, and to what extent it is recognized by the advocates, that depends on the different agencies and the different institutions. Authorities includes here the decided cases, as I have mentioned to you, the textbooks and the articles in the legal journals, certain works of the so-called institutional writers. Avoid this word so-called, it is a bit negative. So here we are, when we are talking about the textbooks, this term of textbook would come in the upcoming slides also. I'll give you an example of this deductive concept. Judge Neuberger, in the case of Money Markets International Stockbrokers Limited versus London Stock Exchange Limited 2002, keeping in view this deductive idea, he has mentioned that I shall start by discussing the authorities. मैं इस केस को start करने के लिए, and while at the time of delivering the judgment, I'll rely myself on the authorities, right? And shall then turn to consider the principles to be derived from the cases. Pehle I'll look into the authorities, and after that I will consider the principles which are already incorporated in the law. I shall then seek to apply those principles to the present case. So that's the ideology of the judge, that if you are talking about the major premise, which is always above the minor premise, so in order to come to a conclusion, I have to look into the bigger picture. And in order to look into the bigger picture, I have to mention the authorities. And as is mentioned in this previous slide, if you can see the last paragraph, such authorities are the already decided cases, the textbooks, the articles in the legal journals, and the writings of the institutions. The other form of reasoning given by the Aristotle was the inductive reasoning. It draws a conclusion from the particular instances. Here, particular instances means different judgments or different case laws. It also has two forms. If you take the instance from a particular, if you take a problem or conclusion from a particular case, or either an advocate is taking the conclusion from the different case laws. So in India, we follow the common law practice and we strictly follow the rule of the precedent, that where we are stuck in between a particular research, we should go and take the view of that particular judgment, the subject matter of which is as similar to the present case. That is how, while arguing before the court as a mooter, you would conclude by asking the judge that it is the responsibility of the honorable bench. We should always give them this leverage that it is the wisdom of the court and responsibility while addressing the bench, that distinguish this particular matter with the previously decided matter, right? This particular session, if we'll talk about, is about the research, that how you should be, going ahead before starting or reading any of the moot problem. So there is no particular single way of doing the research. Every person has a different idea of starting with the research. First of all, I'll tell you that research is nothing but searching the problem or searching the particular idea again. While we are saying that it is research, so you are searching it again because it is already in the picture, it is already decided, but we are making new additions, we are making new modifications in it, but with the help of the different methods. And to research upon this, there are some of the basic models and there are few phases, as you can see on the screen. And it starts from understanding the legal context, conduct the detailed research, finalize the arguments and select the authorities, refute your opponent's case. Correct? Should I repeat this again? Mansi?
No, Paris, we're
Is
receiving
there,
responses
is there
that
any question?
it's clear to them.
Is there any question in between by any of the
No, no,
participants?
no,
Okay.
not as such.
So I'll repeat it again that the overview of the research problem, it postulates that we start with understanding the legal context. This is basically understanding the legal context is talking about the reading the mood problem. Then conduct the detailed research. Once you analyze that what is the problem it is about, then we shall strive to start working upon the detailed research. After that, we have to finalize the arguments which we are writing in our memorials, and we have to select the authorities there and then, that what all are the relevant authorities which would help us to win the matter, whether it is from the side of the in the prosecution or from the side of the defense. Both the sides has been given this positive and negative authority to decide this matter, because and eventually they have to make that particular party win. And lastly, you have to refute the opponent's case, because that is how you are going to establish your matter before the court. So phase one is talking about the general principles of law. General principles of law here, that means the legal issues. In a particular mood problem, you will find so many legal issues which are already somewhere incorporated, and sometimes it is not incorporated. While drafting of the issues, we firstly, initially, what we write that whether we see that whether the particular court has the jurisdiction to entertain the case or not. That is usually the first issue that we take into the picture. And some of the issues are unresolved also. That is directly related to the subject matter of the suit. So now the point is that where will we find these general principles? As you can see on the screen, it is mentioned as the practitioner textbook. By this practitioner textbook, it is clearly understandable. And if it is, even if it is not, I'll tell you that here we are talking about the Bare Acts. Bare Act, it is the purest form of the statute, the official gazette, which you will not get for the reading purposes. It is available online, but the Bare Act which you purchase from market, that is the original text, except the comments which are given below the sections. If you read any of the sections and the non-obstante clause and the examples or the provisos, except the comments which are given below the particular section, the entire document of the particular statute, for an example, Indian Penal Code contains 511 sections, right? So that is the practitioner textbook, right? So these are those principles which are helpful for you, and they are mentioned as it is. As you can see, they are black letter law, means the title of the particular section which is mentioned as it is, as decided by the legislature, and is going to be implemented by the judiciary, that is the court. So it is something which is already given as it is, and it is not something which as it should be. As it should be will be there when it will be decided by the court. It will be accurate, it will be detailed, and it will be completely up to date, right? Then the example of this, I will tell you the Halsbury laws of England and the Corpus Juris Secundum. Corpus Juris Secundum is the American jurisprudence. It is the text of the America, and which is giving you the idea of the common law in the form of the chapters. The chapters are 113 number, and the Halsbury laws of England, subsequently the Halsbury laws of India, which has given the extended form of the various existing laws in the country, right, with the comparative analysis of the with the other countries. So that is how you can make your research extensive, by using such documents and by using such general principles while working upon any of the legal argument. But most importantly, while referring to Halsbury or while referring to Corpus Juris Secundum, we should always look into the practical considerations. And by this, I meant the judgments pronounced by the Indian courts, right? The judgments pronounced by the Indian courts, the Supreme Court of India, or by the High Court. And even if it is a judgment of the Privy Council or the judgment of any of the charter courts like Bombay, Madras, and Calcutta. So these are the practical considerations which should be taken into the consideration, which should be taken into the picture while reading the mood problem in the phase one, right? Moving ahead, whilst you have read the moot problem, now you have to start conducting the detailed research with the help of your researcher. The first and the foremost point is hunt the most relevant and important authorities, right? How how to identify the relevant authorities? You can better do that with the help of the case laws, case reports, because being a student, you will realize that the moot problem which you receive for any of the competition is somewhere connected to the already existing or already existed case law, or a matter which is already decided or it is still going on or pending before the court. For example, the matter of the Sabrimala, which is now decided, but when it was under the picture before the court, at that time, several law schools have conducted the Moot Court competitions over that. For an example, right to privacy, which is now a fundamental right. Earlier, it was not a fundamental right. So that particular battle of the right to privacy, when it was into the picture, so many of the law schools has conducted the, has given the moot problems on the privacy law also, right? So while I'm saying that how to identify the relevant authorities that can be recognized and that can be, identifiable with the help of the case reports, right? These case reports are the weekly reports or the yearly reports, which are being given by the courts itself. The textbooks, right? The latest editions of the textbooks, which are giving you the additional information about the judgments pronounced by the courts in the past 2 to 3 years, right? This will also add the yearly law cases which is pronounced by the High Court and the Supreme Courts. The journal articles, these journal articles are given by the journals like Sage or the internationally recognized journals, right? Or even those journals, those articles which are being given by the law firms. For example, there's a law firm, Nishit Desai and Associates. So they write articles on the commercial transactions. They write articles on the mergers and acquisitions. So these are the articles which are sometimes recognized by the courts also. Courts also mention these articles in the form of their obiter dictum. So when they mention these articles in the form of the obiter dictum, right, they itself become the part of the relevant authority. Correct. Also, if you have to identify them, refer to the footnotes. If you are reading an article and that particular article is talking about the concept of due diligence, for example, so for that particular purpose, you have to look at the footnote, that what is the source of that particular article. While copying that link, you can get to know that how this particular introduction is given in this article which you are reading. Further, how to decide these authorities? आपको कैसे पता लगेगा कि आपको कौन सी authorities को refer करना है या पढ़ना है? So there's a line written over here that separate wheat from the chaff. Concentrate only on the cases that crop most often. I'll tell you an example, as I've mentioned about the right to privacy. That right to privacy was not a fundamental right before 2019 in the country. The battle started back in 2014-15 when the retired judge of the Madras High Court, Justice K.S. Puttaswamy, has filed a case before the court and said that the information taken by the private agency of the information of the individuals, which is the demographic and the biometric information of the individuals to collect the information, is detrimental to their and is contradictory to this idea of the privacy. That my privacy is breached when I have given all my information to a private agency. Giving my information to a particular government agency, would that ways to an extent is permissible or that is justified? Because as I have started this session with the concept of the social contract theory, you are voting the government, and on the other hand, government is providing you the protection, right? So giving information to a government agency to an extent is justifiable, but not to the private agency. So retired Justice K.S. Puttaswamy has filed this matter. The matter went long, and finally in 2019, the decision is given, and Justice D.Y. Chandrachud, who is presently the Chief Justice of India, has pronounced that the right to privacy is a fundamental right. But most importantly, in that particular judgment, you can read it later on, the dissenting opinion, if you'll see the ratio of that particular judgment, the ratio dissentii, the legal reasoning, if you'll see the legal points given in that particular judgment, that is the same points which are already given in the dissenting opinion form in the matter of the ADM Jabalpur versus Shivkant Shukla. I'm reiterating it again. The dissenting opinion of in the matter of the ADM Jabalpur versus Shivkant Shukla, that particular dissenting opinion was given by Justice H.R. Khanna. The same facts was reiterated in the form of the ratio in the matter of the Justice K.S. Puttaswamy versus Union of India, and that is how the right to privacy became the fundamental right. However, the battle of it, if we'll go to the history, not the battle, but if we'll start from the initial stages, Khadak Singh versus State of UP also talked about the privacy thing, right? But finally in 2019, we got this particular thing settled down. So we have to separate the wheat from the chaff. We have to look upon the recent case laws. We have to look into the present scenario, because the judge sitting in the moot court hall or the judge in the real court of law would ask you anytime that what is the present law applicable and what is the present judgment pronounced by my brother or sister judge. Plus, make full use of the head notes. These are the brief summary. If you have seen a judgment, you must have read a judgment. If you will see on the first and second page, after the names of the parties are mentioned, you will see the bold paragraph which are giving the summarized form of the entire judgment. These are the short key terms which are breaked, and after 2-3 words after the full stop, you will find that they are giving you an insight into skeleton about the judgment. You have to read such most recent decisions first before starting researching for a problem. I'm not saying that don't go to the history, because as I can see, this is the third example which I'm quoting when I'm trying to understand about any of the concept, and I'm quoting the history again and again. That is also important to make the court understand. For an example, if you talk about the privacy, so the idea of the privacy was first ever discussed in the world first time in 1890. There was an article by two of the authors. They have first ever discussed that what is privacy. This idea came to India very later. When people got civilized, they got to know that, okay, fine, that this information of ours, if given to others, would be detrimental to our personal prestige. So that way, history is important. But for the purpose of the research and for the purpose of the sources which you are providing to the court, you have to use the recent decisions. Now, how to read these authorities? The judge's reasoning, as you can see on the screen, this judge's reasoning can be divided both in the form of the ratio and the arbiter. Reasoning includes the legal points on which the entire skeleton, the entire judgment is based. The legal issues, that whether the particular court has the jurisdiction or not, whether the party is eligible to present before the court, right? Or whether the laws applicable are in pari materia to the laws already applicable in the previous judgment. Plus the arguments of counsel, they are very important, because whilst an argument of the counsel is mentioned in the judgment, that means the court has tried to marshal the arguments. Court has dictated that particular argument of the counsel and given the opinion over that accordingly to give the concluding remark of the judgment. The phase 3 is any questions in between, Mansi?
Yes, Paris.
Yeah.
We can address a few questions. So, yeah, Diane is asking, like, how do we hunt the most relevant authorities? You have mentioned it in one of your slides. But how do we really hunt these most relevant authorities?
That is possible only by going through the online databases, as Lawctopus is also giving a lot of information about the recent news and information coming from the courts and the other websites and the channels. Plus, we should read the newspapers also. Also, I mean, if it is possible for the students at the time of the internships that they can visit the Supreme Court and the High Court, they can jot down the case laws from there. They can discuss that particular matter with the relevant provisions which is going on, and also while referring to the latest edition of the textbooks, because textbooks always gives you the latest citations of the recently decided matters of the past 3 years. So that is how you can connect and get the information of the recent authorities. So yes, to join the internship, to access the online databases, to read the fresh articles, to listen to the legal news every day, and also by reading the latest textbooks. That is how you
Right.
can actually have an access to the most relevant and the important authorities to crack your matter. And it is easily
Right.
accessible. That is how the advocates and the mooters are winning their arguments.
Right. Yeah. Dhyan, what you've just asked, yes, you can use SCC online. SCC online, Manu Patra, all these databases will really, really help you to retrieve uh, law judgments. Paras, we have one more question. We
Yes,
have
yes,
one
please.
more question from, okay, we don't know her name. So the attendee asks, how should we approach a mood problem in a subject we haven't previously studied?
See, for that, this is a very common practice because, see, I understand when I was also in second year, so the moot I have participated was related to this constitution, right? And the other laws were involved. But with the practice and with the due course, you have to understand this thing. You have to start reading that particular subject matter with the basic context. Read the basic context and the basic content of that particular subject matter. For example, for the Constitution of India, most of the law students, and that's not a problem, they refer to J.N. Pandey. And then they go to D.D. Basu also, they go to H.M. Sirvai also. In between, MP Singh is also there. So in order to understand a concept, you start with the basic book. You start reading the basic judgments of short, of the less pages, right? You are not supposed to go for the long judgments. I'm not asking you to read Keshavan Bharti. Rather, you should read the small judgments of 2 to 3 pages, understand and develop that how the court has differentiated between the ratio and the obiter, how the court has, bifurcated, how the court has given the dissenting opinion. Do not go for the dissenting opinion, because if the dissenting opinion is not acceptable by the major size of the bench, then it is of no use. So that is how you can, approach a particular problem with this objectivity. Understand the purpose of it, understand the, as I've started with this thing, constitutional and jurisprudential essence. The objective and the purpose of that particular content has to be understood first. Take help from your seniors, read more about that particular law with the help of, again, the books, online sources, and the case laws. That is how you can start with your research.
Right. Okay, Paras, we can proceed.
Now the phase three, this is the second last phase. This is talking about the finalize the arguments and select the authorities. So as in the first phase, we have understood the legal context. The problem is now, read by you. You have identified that this is the issue in this particular problem. After 5 minutes or 7 minutes, I will take you to a memorial also, right? So there you will get to know that how things work. So understand the legal context. Now you have read the problem, you have understood the legal issues, you have chalked out the legal issues, you have referred to the bare acts, you have referred to the various text, right? Then the detailed research is also under process, right? You have chalked out that which are the relevant and the recent case laws which you have to study for the problem. And now you are at the verge of finalizing the arguments and you have to select the authorities. As you can see, there's a chart on the screen. This is the select the most weighty authorities. It is talking about that you have to go with the, such authorities which has more credible and reasonable, instance in the court, right? The chart goes from leading student textbooks, avoid this, articles published in respected legal journals, the decision of the foreign courts, leading practitioner textbooks, decisions of the English courts. For example, you are researching upon a moot problem of the constitutional law, and you are stuck at a point on which no law is applicable. Now you are clueless that you are unable to find. However, it is not, possible that on a particular point law is not applicable or you won't be able to find that law. But there might be a situation that you are not finding any law. So there's a concept in English law which is non-leque, NONLIQUET. Non-leque talks about the silence of law or absence of law. So when in your argument, when you will quote the idea of the non-leque, which is given by the authors and the jurists, Harsh Lauterpat and Ilhu Lauterpat, their father and son. So non-leaky, when you will quote before the court will be impressed by that. And the using of this non-leaky concept from the English court is permissible. The Constitution of India gives you that authority to use such foreign judgments and the foreign ideas also. So non-leaky is creating a more impact and a weighty authority over the other arguments which you are giving against your opponents. Right? And there are some other concepts also, if you go for public international law or private international law, and even if you're not going with that, in the Constitution itself, if you are mentioning the landmark judgments, that will give you an extra edge for helping you to win that particular matter. Then, as discussed earlier, select the most recently decided cases, give the differing judgments, and be aware and be wary of the dissenting judgments. As I mentioned you, that dissenting judgments can be mentioned, but if that particular dissenting opinion is not actually and completely acceptable by the other bench and the majority of the bench is not agreeing to that, do not mention that. Do not cite the unhelpful authorities. We tend to, when it happens that we mention extra, lot many cases which are not even directly connected to the moot problem, which are of no relevance. Even if a single point of connection is there, we mention that, but that is not required. Unless the ingredients of a particular section and unless the ingredients of that particular matter and issue are directly connected to your matter, don't use it. Less is more. Less is more means the less you mention, the cream and the crisp you will mention, that will be more visible in front of the court. Right? Otherwise, court will drag you to such issues where you won't be able to answer them at that particular point in time and you will lose the marks. Right? If you are talking about the judicial activism, keep yourself restricted to the judicial activism. Do not go left and right and stick to the particular idea of the constitution or any other matter which is connected to your subordinate act. For an example, if it is a criminal matter and you have gone in the jurisdiction, right? And for example, you are going with the Supreme Court and you are exercising Article 32. Besides Article 32, you can always mention the other articles to support your jurisdiction. How it is possible? Article 142, you can write it down also. Article 142 of the Constitution of India, the content in the title is different. But if you read the objective of this particular article, as this question was asked by one of the participants, that how to objectify that this is the problem, this is the jurisdiction. So Article 142 is giving you a liberty plus it is giving you that authority to seek complete justice from the Supreme Court of India. So there you can mention the court in the idea of the less is more, that Supreme Court being the sentinel on the QY, that Supreme Court being the supreme body and the parent body has this, again, a responsibility I'm mentioning, responsibility to provide complete justice to the party presenting before the court. So there, it is not necessarily that if you are approaching the Supreme Court for the writ petitions, you are going for 32 only. With 32, you can always mention 142. That would create no harm, but importantly, that has to be seen that what is the exact matter in issue. If it is a commercial transaction, in terms of the any of the IPR related matter or directly a matter related to the property, in that case you are not supposed to mention 142, right? But otherwise 142 for complete justice can be sought from the court. Phase 4 is now, since you are arguing before the court and now it is the time for the other party to stand and speak up in favor of them. And now after the completion of the other party, you have to refute them. How you will refute them? You will go for the rebuttals. Then they will go for the sur rebuttals. If obviously sur rebuttals, if permitted by the court. So you have to, your opponent authorities do not represent the law. You have to prove this, that the authorities posed by your opponent, they are not representing the law which is into the picture. That the opponents have misread the authorities. These are not the actual authorities which were supposed to be there in the memorial. Your opponent's authorities are distinguishable, right? तो आपकी authorities जो है वो अगर थोड़ी सी भी distinguishable है, that is how you can disprove the matter before the court. And the opponent's arguments are contrary to the policy. That means the law which is there, the policy which is made by the legislature, the arguments given by the parties, they are completely contradictory, and it is creating that picture of arbitrariness, and then fancifulness, and then a lot of oppressiveness is there, which is creating a huge burden on the other party to decide the matter, and that is how you are getting delayed in seeking the justice before the court. Some of the do's and don'ts which you should take care of: you should always take the effective notes. Look at the citation very carefully, because the style and the format in which you are following the citation, whether it is Blue Book form of citation or Harvard form of citation, asked by the organizers of the Moot Court 19th edition, 20th edition, 21st edition, that has to be taken care of. Then the court in which the case was decided, it has to be very clearly seen, because this is the problem which usually the students commit, that mistake which is committed by the students, that the matter is decided by the court of Madras and you are mentioning the court of the Allahabad. Judges can ask you any time that shows the relevant authority. Relevant authority, by that this means that if you have mentioned a particular case law, right, in your written submissions, so you will be definitely mentioning the main ratio part of that particular judgment. But in the form of the compendium, you have to submit the entire document. I'm not asking you to submit the entire document and the entire judgment in the compendium. What you can do, you can take the printout of the first page, you can take the printout of the last page, and take the printout of that particular page where that particular reasoning and observation you have taken and mentioned in a memorial. That particular paragraph which you have mentioned from the judgment, take the printout of that page, first page of the judgment, second and the last page of the judgment, and submit it before the court, right? So that is how you can prove the court that this is the matter which has been taken from this particular High Court or the Supreme Court. The summary of the principal fact should always be prepared with you. The written submission which you are submitting before the court, the compendium which you are showing them whenever required, but the principal facts, that means the fact sheet, right? The facts which you are supposed to tell the court in brief. The first speaker who will be going to address the court has to give the opening statement. So he might be asked from the court to give the facts in brief. There also, he is not supposed to read the entire story here and wire. He has to just tell the facts in brief. That is the introduction, the matter in issue, and the relief sought from the court. In 3 parts only, that's all. The synopsis of the court's reasoning. This you can connect to that title which I was telling you, that on the first page you get the summary of the particular matter, which is the skeleton of the entire judgment. The important reference which court itself has mentioned. For example, court has several times mentioned Paras Diwan, court has mentioned Akil Ahmed, court has mentioned the Fardunji, the Shah Mullah, right? These are the references which court usually mentions. What you're not supposed to do not underestimate the time that research takes, because this duty of the researcher is at most important. And failing to see the wood for the trees, that means the major and the relevant issues which you tend to avoid in the light of those issues which are not actually important in the matter. And it happens. Always take help from the senior, and then before going to the competition, and then try to read it again and again, try to research more and more, and connect it to the case laws, the precedents, and the latest scenario of the law in the country, which you can easily access from the SCC online, EBC, etc. The sources, which I would say, I have not bifurcated these sources in the form of the primary and secondary sources, but I would say that the case reports, the weekly reports, the yearly reports, these are your primary sources. The practitioner textbooks, I have not mentioned the Bare Acts, but yes, these are the primary sources. Halsbury laws, the laws which are written as it is, and it is not written as it should be. It is also a primary source for your help and the aid. The journal articles, these journals should be properly recognized. Only then that will create some impact factor before the court also. The student textbooks, these textbooks are, you can say, the secondary sources, because these are not the context and the text of the literature of the law which are written directly. These are the commentaries. These are the views of the authors, distinguished authors, which are incorporated in the form of the K.D. Gaur for IPC, the Kelkar for CRPC, Batuklal for evidence, etc. The lecture notes, again, a secondary resource for you. These are the notes which you take from your uh, comparative courses. If you are going out of the law school for any of the training program and the certificate courses, and the lecture taken by the eminent speaker. The legal dictionaries, this is very important because the legal glossary will help you to, cite the, all the definitions and this legal maxims also. The online resources or the online sources as SEC Online, which is available with you, Manupatra, Westlaw, Heen Online, LexisNexis, etc. As you can see, this is before the Honorable Supreme Court of Hindustan. This is in pari materia to the laws of the India. Mool Nivasi case, cause and another versus the Union of Hindustan. As you can see, these are the books which are mentioned that Brownlees and then D.D. Basu on the constitutional law, the law's introduction to the jurisprudence and on the private international law. So such are the sources which, as I have mentioned on the last slide, can be taken care of. You can see the jurisdiction which I was talking about. The Honorable Court has the jurisdiction to entertain the case under Article 32, read with Article 142, clubbed with 139, capital A of the Constitution of Hindustan. 139 capital A was required to mention there because of the requirement of the fact sheet. You can see the now you can see the issues which are framed, as you were asking me that how to recognize the matter, whether the public interest policies. I mean, I'm giving you an insight at how you should go ahead with preparing of the issues instead of just going with a single line issue that whether the particular court has the jurisdiction or not, right? Or just writing with the party is as eligible enough to go ahead with the matter. But how you can write is you can give the issues and the sub issues together in the statement of issues column. Whether the public interest policies affecting individual rights and freedoms are amenable to judicial review under Article 32. So here we are giving the relevance of scope of the judicial review in the present case. That is how a particular primary source is being used to enhance the quality of the argument. Whether there is a non-leakage situation vis-a-vis right to privacy in India. So here we are mentioning the Constituent Assembly debates, the debates in US and UK. These are the such additional sources and the resources which has to be presented before the court, for the reason that will help you to give an extra edge and in front of your opponent. The standing committee reports, these are also again the sources available with you. The current legislative efforts. The current legislative efforts are again the day-to-day legislative practices which are in the picture in the media. An argument about the aforesaid sub-issues. Now again, after that, while closing the particular second issue, we are giving a brief about the sub-issues, that what was the relevance and the objectivity of mentioning such small and such subordinate issues. Lastly, whether this government can ensure the protection of, again, this is again the subject matter issue. The sub-issues as to what extent the government should ensure protection. So basically just trying to tell you that issues under an issue would help the court to, give you a more reasoned judgment. Because the more clear you are there in your issues, the more clear you are in the way that for what purpose, for what reason you are seeking the relief. The court will be in a position to give you the relief in the positive and the equivalent clear manner. Summary should be long because we have mentioned the legal issues and the subordinate legal issues, right? And important is your written submissions, which you can see that lot many, reports are mentioned in the footnotes also, right? The international case laws, the English case law, Powell versus May, 1946. So this you can always mention in your criminal law matters also and in the civil law as well. Correct? I think this memorial is that much helpful for you. Any other question, Mansi?
Paris, can we just go through the memorial again a little slowly so that the attendees can actually, look at it again a little more carefully?
This is the front page. The names of the parties are mentioned, petitioners versus respondent. Then you have to mention the matter in issue, case concerning the privacy. You are submitting the memorial, the memorandum on behalf of the petitioners or respondent, right? Keep it simple. Try to keep it simple instead of mentioning a lot of information on the memorial. Yeah, team code will be there. You can mention the logo of the court also. But if the particular state is in pari materia to your state, then do not use the logo, because it is never mentioned in the moot problem that you are contesting the case from the side of the India. If it is Hindustan or something other name which is mentioned in the place of India, do not mention the logo on your own. After your front page, you will come on this table of contents. This will include your index of authorities, includes the statutes referred, cases referred, books referred. Then it will come your statement of jurisdiction, the statement of facts, the facts in brief, as I mentioned you in the three parts. After that, the statement of issues. Try to avoid mentioning the legal issues, because anytime the court might ask you that what are the illegal issues. This happens. So don't mention legal issues, instead mention statement of issues. You can well mention all the issues. Make this particular page in the automatic format. While you are mentioning about the summary of arguments in the table of contents, make sure that you are mentioning the sub issues also. Then comes your arguments advanced. And lastly, the prayer. Some of the more index of authorities cited, the statutes referred are ICCPR, ICESCR, the Constitution of Hindustan. Then while you are mentioning the cases, make sure that it will look more organized, that your cases should be divided in two parts, Indian cases and the foreign cases. Do not mix them. Use the full citation. And if possible, write the case laws in the alphabetical order. The books which you have referred. Here also you can bifurcate the books into the English and the international authors. This is your jurisdiction page. Just suppose, do not write the entire article over here. If it is article 32, you're not supposed to mention the entire text here only. Use the footnotes. The space of footnotes is given that for that purpose only. Make it times New Roman 10 and with 1.0 line spacing. As you can see, it is very small in the font, and there's not much space between the footnotes also, because it is times New Roman size 10 and then line spacing is 1.0 only. And as you can see, also I will suggest you, if you do not want to mention much of the, just a minute. If you do not want to mention the entire article, you can use just one or two provisions also only, sub articles, and then the entire or the complete article can be shown in the form of the bare act to the court. Like here you can see footnote number 1, just one paragraph, and the second paragraph is mentioned. Then 139A. So if you do not want this page to cover the entire content, so you can also avoid that. These are the facts. As I've told you, the facts are not written that ways. Facts are written that ways only, but the facts are not bifurcated. You can bifurcate them in the form of the introduction, the main contention, and the release sort. The facts are going on. This is a word file actually, that is why the words are going up and down. Statement of issues, as I've shown you before. Highlight the major issues and then, if possible, mention the sub issues below the major issues only. Start with whether. When you are starting an issue with whether, do not put a question mark at the end, put the full stop only. However, whether itself means that you are asking something from the court or the other party, but then try to use a full stop. That will look more fine. Summary of the pleadings. This is the summarized form of the arguments, or this is the summarized form of the written submissions, or the summarized form of the arguments advance. So you are writing here the word summary of pleadings. This is a short version that if in case judge wants to see the context of yours and just to flip through it, so that should be easily accessible to the court, because sometimes usually court do not have much time to listen and to read the matter. So for that purpose, it is given as a part of the convention in your moot memorandum. Now these are arguments supported by the authorities. You can write arguments advanced, you can write arguments, you can write this argument supported by the authorities, because all these issues are supported by the case laws and the books and the articles. You can make these such of the words like prima impression is some legal terminologies in italic form, so that it can be highlighted to the court. You should always mark these Lawctopus and Hans Kelsen with the, whenever you're writing about them, always keep them in the footnote, right? As at first, it is mentioned as at first, Lawctopus took the view, much like Kelsen, that completeness was an a priori proposition of all legal system and not of positive law. Then followed by this, you can highlight the case laws also. Make sure whatever case you are mentioning, either between the case, either write V dot or VS dot, but it should always be in italic, right? R versus Inland Revenue Commissioner, Export Woolwich Equitable Building Society, footnote number 15, right? So V dot, and here not in the footnote you are supposed to make it italic, but in the main submissions you are supposed to make it italics. The reports and all which I have asked you to mention, do not write the entire context, because maybe in the rules of any of the competition it is mentioned that the limit of the number of pages is just 30 pages or 32 pages, including the fact sheet and the arguments, and somewhere it is 30 pages excluding the excluding everything, but only for the arguments. So make sure you are, whatever you are mentioning, just write in brief and give the document in the form of the compendium to the court. You can see this fiat justitia ruat caelum. Let justice be done, though the heavens may fall. The motto of the House of Lords. That is how you can impress the court also. Make it italic always. As you can see this case, the main purpose of Article 12, which is state of the Indian Constitution, 142, the main purpose of 142 and the endeavor to do complete justice has been explained by this court in Manohar Lal Sharma versus Principal Secretary and another footnote number 30. So you have mentioned about the concept of 142 complete justice in the jurisdiction. So that has to be explained also, no? Because court might ask you any time to provide the source that from where you have taken this. And do we have any case law from where we can chalk out that this particular article is relevant for the jurisdiction or not? So such cases can be mentioned in the jurisdiction also and in the arguments also, both ways. I've told you about that the Supreme Court being the highest authority. You see this paragraph. The Supreme Court, as the sentinel on the QY, has been invested with the powers which are elastic and flexible. In Shahid Balwa versus Union of India and others, the court said that Article 136, read with Article 142 of the Constitution of India, enables this court to pass such orders, which are necessary for doing complete justice in any cause or matter pending before it, and in any order so made shall be enforceable throughout the territory of India. The power to do complete justice under Article 142 is in the nature of a corrective measure whereby equity is given preference over law to ensure that no injustice is caused. If you remember initially while starting the session, I mentioned about the justice, equity, good conscience, right? So these are the major key terms. These are the elements of the Constitution of India. These are the touchstone on which this entire document is based, right? So under this garb, under this umbrella, you can always use 142 with the parent article, which is there for your jurisdiction purposes. Constituent Assembly debate, some of them are mentioned. It is given here. Now these all are the arguments which are current legislative efforts. Here this argument is connected to the Article 51 of the Constitution of Hindustan for the promotion of the international peace and security, and it states the state shall endeavor to promote international peace, security, maintain just and honorable relations between the nations, foster respect for international law and treaty obligations. This was mentioned because in the preamble of the Constitution of India, the most important key term is fraternity. Bhaichara is very important. So that is how it was connected. I'm coming to the prayer now. Wherefore, in the light of the facts and circumstances of the case, issues raised and arguments advanced, and authorities cited, you can change these words on your own. Issues raised, arguments advanced, and authorities cited. Counsel for the petitioners humbly prays before the or to the honorable court to grant and declare whatever you want from the court or pass any other order deems fit in the interest of justice, equity, and good conscience. For the act of kindness, I shall be forever obliged and grateful. You are the counsel of the petitioner. In the criminal matter, you can mention SD also, right?
Right, thank you, Paras. Thank you so much. Uh, all right, guys, we'll also address your questions in a while. But before that, I would like to share my screen, and I can see we have a lot of questions related to how do we draft a memorial and how do we cite cases, all of that. I get that. We'll also, I'm getting there. But before that, I'll quickly share my screen with you. And yeah. Okay, is my screen visible to all of you? Paras, is it visible?
Yes, it is visible.
Yeah, okay, guys. So, this particular webinar was more sort of about how to conduct legal research, particularly legal research for a moot court competition. A moot court competition has a lot of components. It has, of course, legal research, it has drafting of memorial, it has oral arguments, it has citation techniques, it has a lot to do. I can see a lot of you have a lot of questions regarding drafting of memorial and regarding arguments. Guys, first of all, what we were trying to cover here was only about legal research. So, in order to know better about the oral arguments, the citation techniques, all about memorial, how to cite cases, all of that, to in in short, to explain everything about a moot court competition, we at Lawctopus Law School offer you a course uh, called Moot Courts and Competition. Along with that, to sharpen your skills of legal research and writing, we also have a course, online legal course on legal research and writing. So, first of all, you know Lawctopus from quite a while now, and if you know Lawctopus, you know one thing for sure, that we post a lot of legal opportunities. So, we try to keep everyone aware, especially law students, aware of various legal opportunities that are available, and we help you to avail those opportunities, and so that you can have inspiring and inspired careers. Now, why moot course? Like Paras has already explained you in detail the importance of mooting in law schools, and how important it is, how vital it is for a law student to participate in moot court competition during his or her law school journey. It is basically going to enhance your analytical skills, your research skills, your argument skills, and it is the first step you take towards becoming a better lawyer. And why legal research and writing per se? Because no matter in which field of law you pursue, if you go for academics or you go for litigation or you go for judiciary, legal research itself is something which is going to be there for you. It doesn't matter. There is no legal professional who can pursue in the field of law without knowing legal research. So, mooting and legal research, these are two core skills which every law student should learn during their law schools, which we actually which is not, sadly, not part of our curriculum, but we are expected to learn it. So we at Lawctopus provide you these two courses, which you can do individually as well, or you can do these courses together, so that you ensure that you ace these skills and build a really bright legal career for yourself. Now, as I've already told you that mooting is not just about legal research. Yes, in today's webinar, we were just trying to cover the legal research part, and Paras has elaborated it in detail for all of you. But it is also about drafting, writing, arguments, presentation, and definitely about teamwork. If you know moot court competitions, a moot team is comprises of three people. There are going to be two speakers and one researcher, and it is a teamwork. All three team members have to work equally. So, in order to win a moot court competition, um, so the sooner you learn this skill, the better it is going to be for you. And now, so because the mooting culture is actually building a lot in the law school, so those law students who have a good mooting experience, they are able to bag more good internship opportunities, and even law firms now, they prefer those candidates who have had a good mooting experience in his or her law school journey. So we at Lawctopus provide you two courses. One is of moot course, and one is of legal research and writing. Both these courses are going to be of 2 months. And in through these two courses, you can actually learn the art of mooting, and you can learn the art of legal research and writing, and you can make a really better future for yourself. In these courses, we provide you really expensive and really excellent reading modules, which are prepared by some amazing, experienced faculty. There are going to be live lectures. There are going to be recorded video sessions. There is going to be online for discussion forum where you can do peer-to-peer learning. There are going to be assignments, and in the Moot course, there is going to be an online Moot Court competition to give you first-hand experience of how Moot Court competitions are. So let's just say, as I just saw that most of you all are in either in their first or second year of their law school. So I am sure um, you might not be very well acquainted with the entire process of mooting. So give you the first hand experience of moot court competitions. We also provide, we teach you how to moot, and then we let you participate in a competition, which is not, there is no winning or losing involved. It's just about learning, but you get to present your arguments. There are oral rounds, and you get personalized feedback from our faculty then and there in the oral rounds itself. So there's a lot of learning involved in that course. Like I just said, there is a real online moot court competition where you will argue before the expert mooting judge and you'll get a feedback. So even if you are an introvert and you are shy, or you have stage phobia just like me, don't worry. You will be taught from scratch, like what all do you have to do. It will also include uh, drafting of memorial. Like I can see most, I can see there were a lot of questions regarding how do we search cases on SCC online or Manupatra, or how do we frame issues, or how do we what do we write in the prayer section. I get that, that's something, if you're new to mooting, you will definitely have these questions. In this course, we teach you all about mooting, all about mooting, that is, which you will actually will not get to learn in your law schools, because our law schools somewhere expect us to participate and win the trophies for us, but they do not really teach you how to prepare yourself for the moot court competitions. You will be arguing, you will be in the moot court competition with the learners, with those students who have enrolled for this course with along with you, and you will be arguing with them in the moot court competition. And it's, there is no winning and losing involved in that. It's just for the sake of learning. And now talking about the legal research and writing course, guys. So legal research is a prerequisite to mooting, but it's not just limited to mooting. Like I just said, in whichever field of law you pursue, legal research is going to be there. You cannot just escape it. And it is definitely, the more you develop your skill of legal research and writing, the more your analytical skills, your thinking ability, everything is going to improve. And it will also help you to bag much more better job opportunities in your life. So in this particular course of legal research and writing, we teach you how to write a legal research paper from scratch. Now, if I tell you about myself, currently I am pursuing PhD in law, and I've done LLM from a NLU. And guys, I've my professors expected me to know how to conduct legal research, but it was not part of our course curriculum basically. But and none of the faculty members ever took pain to even teach us. So since you are in the early years of your law school, the sooner you learn this skill, the better it is going to be for you. The your law school journey will be better. If you want to pursue LLM or PhD, it will be better for you. If you want to go for judiciary, it will be very, very helpful. And if you want to go for litigation, legal research is something, legal research will make you a better lawyer. So it doesn't really matter, like I just said, it doesn't really matter in which field of law you're pursuing. If you're a first year law student or even an experienced or expert faculty, you will need legal research and writing. So I would just suggest it to you that since you are in the early years of your law school, you should learn these two skills, the skill of mooting and legal research and writing, so that you make your future future years much more better, your law school journey much more better, more experience, more opportunities you can avail if you have aced these two skills. Like the same way, in this course there are going to be reading resources where you will be given excellent reading material. You will be having recorded video lectures from ACE legal researchers. You will be having self-assessment tests. You will be having assignments and feedback. There are going to be live lectures. There are going to be 8 live lectures in total. And there is, of course, there is going to be a discussion portal where you'll be given, you can have the peer-to-peer learning experience. Apart from that, if you join courses at LLS, you will be given you will be given a preference by I mean you'll have better internship opportunities, and you'll be getting an opportunity to publish your legal research paper um, in a Lawctopus journal academic. And you can also get a chance to be a peer mentor for future batches, which is a paid position offered by Lawctopus. And definitely there's going to be CV advice, career counseling, how to make your CV, how to make your LinkedIn profile, all sort of things. If you are interested in any of the course, either legal research or writing or moot course, then we have our new batches starting from for legal research and writing. We have a new batch starting from 5th of March, and for Moot Course and Competition, we have a new batch starting from March 10th. You can buy these courses separately, or you can even buy a bundle course of legal research and writing. The link, the registration link of all these courses will be shared with you in the chat box on the WhatsApp group and also on your emails. So don't worry. There is a catch for you. If you register for this course by tonight 11:59 p.m., then you will get a waiver of 20%, but you have to use the coupon code LRMCC20. You can just note it down. If you use the code LRMCC20 by tonight 11:59 p.m., you will get a 20% off in any of the course. And if you do not register it by tonight, but you have decided to register to our courses by March 4th, that is Saturday, then you have to use the coupon code LRMCC15 and you'll get a waiver of 10% on our courses. Um, Apart from that, just give me a moment. Yeah. So the link, right now, the certificate, coming to the certificate, guys. Right. The link of the certificates will also be shared with you, and the certificate generation code will also be shared with you. But before that, we want to take a few questions, and so if you have any questions, you can just write it down to us in the Q&A box till the time. Paras, if you allow, can we just take up a few more questions?
Yeah, we can take that.
Yeah. Okay. Okay, Paras. So, okay, we have a question like what to do if law and case laws are silent on some aspects, principles of natural justice, equity, etc.
As I mentioned and shown in the memorial also, there's a concept called non-leakage. That's non-leakage, or you can call it as non-liquid also. So non-leakage says that whenever there is silence of law or absence of law at that point in time, that by using this particular term or by using this particular idea, the court can allow you to move further to seek the justice. This was given by Harsh Lotapat and jointly by Elihu Lotapat. that is given in one judgment. I'll not be able to tell you the exact name, but yeah, Supreme Court has used this term for twice.
Okay. And we have another question. Please tell how to answer issues and frame persuasive arguments.
Can you repeat the question, please?
How to answer issues and frame persuasive arguments.
That is only see, for framing the issues is not a problem once you are well versed with the mood proposition, right? Once you have read it several times, it depends. It depends upon the subject topic, subject matter. Once you have read the problem thoroughly, right? Not I'm not asking you to flip through it. Just read it thoroughly. After that, you can check on what law points the direct law is getting corrected, right? It is a constitutional law matter, or for an example, it is a matter of a civil suit. There, section 9 and section 10, as we all know, it is applicable. So for that, you are taking the jurisdiction of section 9 of the Civil Procedure Code, right? Now, taking just section 9 for the purpose of a civil suit of the jurisdiction is not justifiable to the court. There's a judgment called Isabella Johnson versus M.A. Susai. That entire judgment, the ratio of that particular judgment is broadly based upon that how you can validly present a matter before the court as keeping in view and lieu section 9 as a jurisdiction. Then Patel Roadways case also. So there are such of the case laws that can be helpful for you for recognizing the legal issue, and for the persuasive argument that is possible with the fact sheet. You are not just supposed to, just go with the case laws. Your argument should also, not fully, but yeah, some of the partial arguments can be cooked up. But such cooked up arguments also has to be in line with the moot court. Any argument cooked up should not go beyond the ambit of what is mentioned in the proposition.
Yeah. Paras, we have another question. How to take case laws and how and could you mention any free websites for it?
There are not much free websites for it, but I mean, I would not suggest you to go with Indian Kanun. What I will suggest you that if whenever you are searching a case, just refer that case from 4 or 5 various websites which are using them for free, right? Like IP Leaders is using, for example, or any other Indian Kanun is there, or for that matter, any of the law firm has mentioned that case. No wonder that law firm has given their own justification, not when they have given their own version of that particular case. But usually, such version of their case would help you to, explain that matter to the court. While mentioning that matter to the court for presentation purposes, give them in hand the actual text of the Supreme Court website. For explanation purposes, take the reference from the, open and free access to the Google. For otherwise, Manupatra is paid, SEC Online is paid, all such platforms are paid. But you can always take reference from the various law firms' online websites and the research articles, because they actually mention such case laws.
Yeah, before we take another question, I want to add something here. Guys, if you are interested to enroll with us for any of the courses, I am sending an expression of interest form, which is you in the chat box. You can fill that form. I am just sharing the link right away. Please, and if you have already, if you will fill this form, you will be eligible to get a free reading resource for Moot Court and competition course. And I've sent the EOI form in the chat box. Apart from that, I've also shared the certificate link and certificate code in the chat box. I'll again share it with all of you because there are a lot of messages coming and it's just the message vanishes. So there is a link to EUI form, and the certificate generation link is also there for your pursuit. Yeah, Paras, coming back, we have another question. So SCC Online, Manupatra, they all have like a lot of cases, thousands of cases on a particular topic. How to narrow down the cases to most relevant one for us to use to be used in a memorial?
There's a in SEC Online, Heen Online, Westlaw, all such reputed law browsers. I mean, search engines basically. There's always a column of search, right? So whatever your topic is, suppose your topic is arbitration, right? And or suppose your topic is it is related to right to property. So the moment you mention and search in the search column that particular topic, you will get the judgments related to such particular topics. Along with that, you can mention the year also. The way you mention the way you search your case laws on the Supreme Court website, either with the name of the judge or with the name of the year or with the name of the case law or with the name of the advocate, that way you can search there also. But the most feasible way is to mention the parent topic on which you are looking for the research, and that can be easily checked on the Westlaw and Heen Online also. For example, if you write on the Heen Online non-leak, you will get several articles in case laws of the English origin also and the Indian origin also. However, in Indian origin there are just 2 or 3 only, not more than that.
All right. Okay, Paras, thank you so much. Guys, I've again shared the EUI form, expression of interest form in the chat box. Please know if you fill this form, you will be eligible to get a free reading resource from Lawctopus Law School for Moot Court Competition. Also, the certificate generation link has also been shared with all of you. You will get the recording of this session. It will be available on YouTube, and it will also be available on the WhatsApp group. If you are still not on the WhatsApp group, I'll also share the link of the WhatsApp chat on chat box, and you can join that group now. Yeah. So I've shared the chat WhatsApp group chat link on the chat box as well. I'm again sharing the expression of interest form link with all of you on the chat box. Please save few minutes and fill this form. Please know that you will be eligible for free reading resource. And again, I'm sharing the certificate generation link with all of you. Okay. All right, guys. If you have any questions, you can just write to us, but it should be related to webinar. It shouldn't be generic. Yeah, the WhatsApp chat has already been shared with all of you.
One
Okay.
more thing I wanted to mention, that the questions which are remain unanswered, is it possible that I'll write all these question answers, answers to all these questions, and I can share with the Lawctopus Law School, and that can be circulated to these participants who have been, listening to us from like a long time.
Paras, mostly the questions that are remaining now are it's not related to legal research.
Okay.
It's more about the memorial and the arguments. So
Okay.
that's what was that was not basically the agenda of the webinar. So I'm not addressing those questions at this moment. So that is all, guys. Thank you so much for joining, and thank you so much for staying for attending the webinar till the end. Um, Thank you so much. Have a great Sunday ahead. Thank you so much, Paras. Bye, everyone.